Good morning. Did it again. There was a huge lag between me clicking on start stream and my intro. And you guys say you don't see me before the intro. So I'm just sitting here like an idiot wondering if I'm live or not, just staring at the screen. And finally I said good morning because I thought, well, maybe they're just sitting here wondering why I'm just sitting here staring at the screen. And then the intro played. Hi, everyone. My name is Debbie. Welcome to my channel. We are on our part 100 of the Phil Spector trial. Can you believe we've done this for 100 days? It hasn't been in a row, and it hasn't been for great periods of time of day, but we've done it for 100 days, y'all. That's a lot of trial. And we are on their part. I don't know yet. We're almost done. 224, which was going to be, yeah, was going to be 2 hours. And then I had a fibromyalgia flare. Literally, I had just said, man, I wish we could get through this today, but it looks like close in front of me. And then I started hurting. And I waited, hoping it would go away, and it didn't. And so it was 18. The timestamp was 18:23 when I finally logged off. So we got through 18 minutes of a 2 hour plus because there was another part after that charging conference before I had to quit. I felt so bad. I'm so sorry, y'all. I'm so sorry. But, ugh.
It's been 84 years.
Sluggish today, StreamYard. It wants to do everything on a delay today. Come, it's not going to do anything when I click on it. It's going to wait 30 seconds and then do it. Yeah, I have something called costochondritis. And let me tell y'all, fibromyalgia is the gift that keeps on giving. I have had fibromyalgia since I was a teenager. I wasn't diagnosed with it until I was in my mid 20s. What are you doing now? Sport TV? Is none of my tech going to work right today? Oh, there it goes. Um, but this just started, I don't know, 5, 6 years or so ago. It's where your ribs meet your sternum, there's cartilage, and you get inflammation in the cartilage. And because fibromyalgia is muscle and soft tissue, it gets inflamed and it causes pain, and then all the surrounding muscles hurt. So it's kind of radiates to my back and my chest muscles went everywhere, and it's just like, ugh. And I had a heating pad on it. Usually a heating pad for a few minutes will help, and it didn't, and I had to go lay down. So I'm fine now. I also needed medicine too, and I didn't wanna be like, "Ugh," on the stream, so I went and I laid down, and it took a while to pass. Sometimes they pass really quickly. Just eat on it, I guess, calms down the nerves and inflammation in the flare up of the muscle fibers or whatever is happening. Sometimes that's all I need, and then other times I need to go lay down and rest and not move, and that's the way the one yesterday was. So I'm fine now, but I am so sorry because I thought we were at least going to be able to get up to closing arguments yesterday, and it just so I apologize, but and that is why I can't work. So yeah, I look normal, don't I? But that is why I can't work because I can't do that if I have a paying job where I have to go lay down all the time. Hi, Jill. You're awake. Yay. Hey, Nancy. Yeah, I'm okay now. Okay, Nancy. I mean, Jill. I mean, dang it. Judy. uh, Judy has trivia. When the limo driver was initially interviewed by police, he reported that Spector had left the house with the pew pew and returned later. And they were having a big discussion during um the exhibits about letters that were written on Yeah, my mom used to do that too. I was the only girl. I Randy, Larry, Glenn. I'd be like, "Mom, I'm the girl. Remember? I'm the girl. I'm your only girl." I get call all my brothers' names. All right, StreamYard. Thank you. So they were talking about letters they wanted to be sent back to the jury where the limo driver was only testifying because he knew these letters had been written on his behalf. And they were like, "Well, he testified that he knew the prosecution was helping him with his immigration status." But he didn't know. He didn't know what letters they were writing and weren't writing, and so there was a big thing with the limo driver. The big, big thing with the limo driver and all the stuff that was done on his behalf for his immigration status. He didn't know what they were doing, and he didn't testify because he thought they were going to help him. That was like a completely like deceptive thing. Like the defense was like, "Oh no, he's only doing that because they're helping with the immigration status." So those letters need to go to the jury so they can see why he testified. I was like, "Come on, people. No, he was doing the right thing. Trust me. If someone's here illegally, they're not going to volunteer information to the police. They're not going to go, "Oh, I'm going to go to the police with this because then they'll have immigration status." No, that's how that works. Okay, 1823. Come on. Well, 18. Oh, 18. Where is it? 1824. Close enough. Because you guys know how bad I am with that slider. Go too far back, too far forward. Why is StreamYard? I shouldn't complain. It's not crashing. It's just taking so long. Every time I click something, it takes forever for it to do it. Come on, StreamYard. Why are you taking so long? It's like it's on a excuse me. It's like it's on a delay today. Okay, I'm gonna take the banner off. No, I'm not, because it won't let me go to the banners. Oh, there it does. It's just everything's delayed. I guess it's still asleep, Nancy. Okay, here we go.
.222 evidence.
The only thing we would suggest, Your Honor, is that this is presented in this courtroom or during a jury review. I just changed the A to the since there was a jury review in this case.
And you'll join in that? Okay, both sides are requesting it then. Thank you. Yes.
Hey, Tricia.
Defined.
We join in the request, Your Honor.
Okay. .224 excuse me, evidence, sufficiency of evidence.
We join in the request, Your Honor.
This is, I'm sure the press never watched this. This is really law and order evidence review, evidence jury instructions, which I don't see how they couldn't be a smash. I mean, maybe it's just me.
They'll be lined up around the ball.
Definitely, and you know, perhaps we can work out a profit sharing agreement among ourselves. Okay, this is the nuts and bolts. This is why they don't show it. 225 circumstantial evidence. It looks like it's been really been modified, mental state. As requested by the plaintiff is modified. Well, it's not really modified. It's just taking out what's already in there. So edited more than modified. Okay. Um, 226 witnesses, and it's been both modified.
for a 226 instruction. The first emendation of any other impermissible bias.
Borne out by the evidence in the case, so we believe it is appropriate.
I believe you can argue it. I believe it is also covered under the term personal relationship, and you're free to argue it. I'm going to take the language out and give it without that language.
Yes, Your Honor.
All right. Anything else in that instruction?
Yeah, turning to page 2, we agree with the deletion of witness's character for truthfulness, that there were no character witnesses here. But the next deletion was the witness promised immunity or leniency in exchange for his or her testimony. That should read, was the witness promised leniency in exchange for his or her testimony. We don't believe there's any evidence that would support a claim of immunity, as that's generally understood in a criminal case, but a jury could find on this evidence that there was leniency in terms of the immigration proceedings for Mr. Souza, and therefore that ought to be a factor that's left in for the jury's consideration.
I agree that something has to be done. There at least has been an issue. Some immigration consequence was offered to Mr. D'Souza, and therefore that has to be, I think, delineated.
I don't know if it's liens here. I think it was a postponement. As he testified.
We probably could use the language, was the witness promised anything in exchange for his or her testimony, and therefore the parties are free to argue it as appropriate.
All I would suggest, Your Honor, is we say any benefit.
Any benefit is fine. That I don't have a problem with that. That's fine. Okay.
We can live with that.
Okay.
The words "any benefit."
Right. Promised any benefit in exchange for his or her testimony.
Who strike immunity or leniency.
Right. Okay. All right. Are you going to join in with that language now?
We will, and we join in the striking of the last emendation if the evidence establishes that a witness's character for truthfulness is not been
All right.
discussed.
Thank you. I don't see 251, which shouldn't that be in there?
Can we take a second to glance?
Union of act and specific intent or mental state?
Well, I think that's contained in the.
Our position
Is it
is that's
contained in-
contained in the homicide instruction.
is.
Maybe. Let
It is.
me see. Let me just go through the use notes and see what they say.
Yeah, we looked at that last night.
One thing I find interesting is the use notes certainly do not single that out, which you think they would have caught. I mean, I know how much work went into the preparation of these instructions. It doesn't mean that mistakes weren't made, obviously. We're still in the process of sort of getting appellate opinions on CalCrim, all of which have upheld the instructions so far. I'm going to put a paper clip here. If I think it's needed, I don't think anyone would object. It's just a question of it will be duplicative or not. The court certainly has a sua sponte obligation to.
Well, we think that we probably do. I mean, if you think it's sui sponte, then you're going to do that. But I think it becomes confusing, and the mental state is specifically addressed in the instructions.
Okay.
Your Honor, we did, and I left this off my list, I had overlooked this, we did in the list that we supplied to the prosecution request 251.
Okay. I'm going to take a look at it, and if I think it's necessary, which would be it's a sua sponte duty, then I'll give it. And
And we can,
It's not going to change anyone's argument. It's not going to change any material element of the case or how you proceed with it. I'll just take a look at it.
that's true, and we'll we'll think about it, but remind us when we
Okay.
get to 520, there's a paragraph that we think specifically addresses this
Okay.
and makes it less confusing. But
All right.
in any event.
See, there's one thing we do need to, before we go past 250 and 251, I haven't looked at the weapons enhancements, because sometimes those are general intent crimes and everyone overlooks them, that the jury has to be instructed. Let me take a look at the indictment.
It's a 12022.
Okay.
You're looking at Calcrim 252 in conjunction with that?
No, Calcrim. I think you said Caljic. Maybe I misheard you. Yes, I'm looking as to the 12022.5A1 and 12022.53B, the specific language. Take a look. It's a general intent. It's mere usage. And so therefore, the general intent, if I give 251, I'll probably have to give, rather than that, I would have to give 252, union of act and intent, general and specific together, and then you delineate which it applies to.
Well, Your Honor, and this may, we asked for 251, but the court has raised an issue that may affect our request on that.
Okay.
This is a situation in which there is no way that, well, at the moment, given the instructions that we've requested and the prosecution has, which only have the charged offense of second-degree murder, there is no way that Mr. Spector can be found guilty of use unless he is found guilty of second-degree murder. So giving the jury a suggestion that there would be a way that the use could be found by finding a different mental state than was involved in the charged offense, I think would be extraordinarily confusing. So if the court were thinking of giving 251 and 252, then we might join in the prosecution's suggestion that we simply give the mental state in the context of the murder instruction.
Well, I have to instruct them on general intent as it applies to the allegation under 12022.5. That's simply the law. I don't have any chance. I don't have any choice not to. First of all, only murder to go on to the enhancement allegations, and then it tells them how to consider it. It basically says this is what you do. There should be, I don't know if anyone's bothered to include, I haven't gone through the package, the use instruction. People are not. Yes. Okay. It's not confusing.
Okay.
It's not a problem. So I will have to instruct. I'll either do 250 or I will do 252. It just depends. If I end up giving 251 because I don't think that the murder instruction is adequate as an instruction covering the intent, then I would give 252, which is general and specific together. It just keeps you from giving two separate instructions. Right now, just tentatively, I'm going to list 252 and ask the people to pull that, and then I'll make a decision, either today or we'll take care of it, but 252 will have to be pulled.
Will do.
All right? Let's see.
So the question mark remains on 250.
The question mark remains as to how I approach it. No, the question mark would remain on 251. If I don't give 251 because I feel the homicide instruction is adequate, then I would have to give 250.
Okay.
If I believe that it's not adequate in the homicide instruction, then I will give 252, which is general and specific intent together. Let's see. All right, on to Calcrim 300. 301, testimony of a single witness.
We joining that, Your Honor?
Okay, there's no corroboration. There's no required in this particular case. .302, evaluating conflicting evidence.
We're joining that, Your Honor.
Thank you. .303, certain evidence was omitted for a limited purpose, definitely, because I've talked about it to the jurors, you know, how to
You gave a
consider.
number of limiting instructions during
Right.
the course of the testimony.
Okay. The defense position?
We joining that, Your Honor.
All right, thank you. And I guess this is a good time. If the parties would look at, I can get you the site, People versus Cox. I do want to give an instruction. I just think it's important. I think I did limit it verbally, but if I didn't, or it depends on the language I used, about the use of guns, about what they can consider it for. In this case, it has some, it has to do with the ownership and who had the gun and access and whatnot, but you can't just, Cox talks about it, you can't just use it for, you're a bad person because you own guns. I want some instruction that goes along with that. So if the defense wants to draft it, if the prosecution wants to draft one, I'll take a look at it, but I do want what I'll call a Cox instruction, which is just a made-up name.
Something to the effect that it was limited to the use of,
Right.
for the limited purpose of proving ownership of the weapon
Right.
involved in this case.
And it would have to also add, you may not use the fact of gun ownership to, infer that the defendant is a bad person, and therefore you can use it for guilt or innocence. I just think it's important. Okay.
Your Honor, do you have the Cox site?
Here, I'll get it for you. I have it sitting open. Just grab it.
Thank you, Your Honor.
You're welcome.
Your Honor, the next one is 306, which may be the most extended discussion. Of course, we'll do it any way the court wants. I wondered whether we want to pass it and come back to it.
You can pass it and go through the ones that are really not in contention. I'll take 306 out and we'll talk about it. And I also have your proposal.
On 316, I forgot to delete the words alternative A and alternative B.
Okay, I'll look at that. We have no need for eyewitness identification in this case. So
No.
it's not an issue. All right. 316, witness credibility, other conduct. I'll take out the alternative language. Let me take a look here. Yes.
Your Honor, my understanding is that alternative A is appropriate because Melissa Grosvenor
That's correct.
has suffered a felony conviction. And as far as I know, the only evidence which would support the giving of alternative B is that there was evidence that Ms. Grosvenor was committed a theft of a plaque, which wasn't adjudicated. I'm concerned that if it applies to a single witness, that the broad language here might lead to the jury to feel that this is a general instruction when there was only one witness as to whom it would be given. So I would submit that a witness in both A and B should be changed to Ms. Grosvenor.
Okay. Pete.
We would object to that. The jury instruction is designed to allow the jurors to infer what they will from the evidence given. They can argue that. That's what this is here for.
Well, but this, are you do you disagree that this instruction applies, that both elements apply only to the witness, Melissa Grosvenor?
That's why we have it in here.
Well, could we have a moment?
Yes, because I would be, because I want to, if you will, pinpoint this, it only applies to that one witness. And I don't want the jury going off and trying to figure out how to apply this. It is specifically as to her.
Absolutely. And, well, was there something?
I do this all the time in jury instructions. If an instruction applies only to a specific witness, I use the witness's name. So
Then we should use Michael Bodden and Linda Kinney Bodden's name with regard to the witness credibility insofar as a personal relationship is concerned.
I disagree with that. I disagree. Because that applies to personal relationships, may apply to more than one witness. And the bottom line is this is very specifically addressed to one witness, and there is a certain danger if it is used by, more a danger of confusion than anything else.
Could we have just a moment?
Yes?
Judge, we'll submit on the court's indication.
I will modify it to include the name of the witness that it applies to. Join?
Yes, Your Honor.
All right, thank you. Prior statements as evidence, 318.
We'll join in that, Your Honor.
All right, thank you. .332 expert witness testimony.
We'll join in that, Your Honor.
Okay. .333 lay witness.
We'll join in that, Your Honor.
Thank you. .351 cross-examination of character witness.
I think that wouldn't be appropriate.
Yes, Your Honor.
Withdrawing it?
We don't think that applies.
Okay, so
Right.
it's withdrawn. .355 defendant's right not to testify.
We'll join in that, Your Honor.
Okay. .358 evidence of the defendant's statements.
We join in that, Your Honor.
Okay. 359 corpus delicti.
Your Honor, we're going to object to this.
Okay.
It was requested by the people, which is understandable. It's probably a situation in which there's a fear that since it's a pro-defense instruction, if it were omitted by oversight, it could be claimed as error. But we're prepared to object to it, Mr. Spector object to it, and let me explain the reasons why, so it's clear that it's a tactical decision on our part that couldn't possibly later be a claim of error on the court's part. The court has heard motions for a directed verdict of acquittal under 1118.1, both at the close of the prosecution's case and at the close of the entire case. And the court denied both of those motions. And in doing so, whether explicitly or implicitly, the court effectively found that there was sufficient evidence apart from, in this case, the statement of Mr. Spector testified, or the statement that Mr. Zuzas testified to, that he heard from Mr. Spector that I killed someone or I killed her, that there was sufficient evidence other than that to satisfy the corpus delicti rule. And the corpus delicti principle is really one that you only argue to a court, because you're just not going to get up in closing argument, certainly not in this case, it's not going to happen, and say to the jurors, you have to ignore that confession because you can find that even if you found the confession credible, there's insufficient other evidence to form a corpus delicti. So it's not an argument that's going to be made, it's not an argument that would be persuasive to a jury, and on the other hand, I find this instruction, and I always have found it, and I know other people do as well, very, very tough and confusing, because on the one hand, it says that other evidence can be slight, and then later on says that you have to prove the defendant guilty beyond a reasonable doubt. It really introduces two separate evidentiary standards, which are difficult enough for lawyers to deal with, and I think impossible for jurors. And I think it's just confusing. I think it's an instruction that's designed for the benefit of the defendant. We have relied on it in making our 1118.1 motion. We will not argue it to the jury, and it would be our desire that the court not give it.
I appreciate that. I fully understand your argument that the court has a sua sponte duty to give it, and I don't think that's something that you can waive and say, okay, well, we made a tactical decision. I believe I have an absolute obligation to give it, and it's a correct statement of the law, and I will give it.
Thank you.
All right, thank you. Court? Okay. Is it ticking?
It's more cookies you're going to
That's right. This time it's
trying to redeem themselves.
it's a cake this time. It's not going to work.
trying to finish the job.
That's right. That's right. Calcrim 370 motive.
We join in that. Well, no objection to it.
No objection. Okay. It'll be given as requested.
That was 370.
370. All right, 371. This is one of the ones I believe you wanted to specifically discuss.
Yes, Your Honor, we'd ask for an offer of proof on the evidence in the record upon which the state is relying to request 371.
Okay.
Actually, Your Honor, the evidence showed that when Mr. D'Souza saw Phil Spector at the door, he was holding the weapon. We know from the evidence that the gun was later found under the left foot of Lana Clarkson, right foot. There's also blood wiped off the weapon and off of her face. He clearly moved the weapon and planted it under her foot to make it look like perhaps she fired the weapon.
One thing I would state, if the court gives it, I would like it to be very specific.
That's fine.
In other words, to pinpoint it as specifically what it is that the allegation is. Do you wish to be heard on that?
Your Honor, if the court gives the instruction with the evidentiary reference in it, in this, and we'll come back to this in another instruction, under Calcrim 220, I believe, the 224 rather, it is the obligation of the jury, if they're going to rely on a fact to convict, as part of a circumstantial evidence case, as this case is, they have to find each fact necessary to the conclusion of guilt proven beyond a reasonable doubt. So if the court gives the instruction, we're going to request that the court add the sentence that before that you can rely on the fact of potential fabrication to convict, you have to find that fact has been established beyond a reasonable doubt.
I would disagree.
I don't think that's a statement of the law. It's not each fact. You have to find each element beyond a reasonable doubt. There's a difference between facts and elements.
Well, Your Honor, I certainly agree with that, Your Honor, but when we're dealing with a circumstantial case, the court is going to instruct the jury that before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt.
But it's not an essential fact. It's not something that has to be. It's merely a fact that is there for them to consider. It's not an essential fact. They don't need to, if they didn't even have consciousness of guilt or suppression of evidence, they can still convict Mr. Spector of murder.
I absolutely agree, Your Honor. But the instruction that we would be requesting is that if they're going to rely on the fact of fabrication as a fact upon which necessary to the matrix of evidence to prove guilt through circumstantial evidence, then it is a fact along with every other fact necessary to that conclusion that would have to be proved beyond a reasonable doubt.
Okay.
We agree it's not an element, and we agree that they can ignore it entirely. It's just that if they're going to rely on it to convict, a proposition they rely on to convict, then it has to be proved beyond a reasonable doubt.
I'm going to have to take a look at People versus Watson at 46 Cal 2nd 818. It's in the use notes. Talks about that issue. People can both sides take a look at it, see if you can come up with a specific case. I'm going to give 371. I'm going to make it specific as to the gun under her leg, and then whether we need to add that language, if somebody can come up with a specific case.
Well, Your Honor, our view is it's not just the gun under the leg, it's also the wiping of the gun, wiping of her face, changing the crime scene.
There's a series of...
Well, why don't you specifically, and you can list such as, in other words, altering the crime scene, including, the following facts.
That's fine.
Okay. And we'll take a look at that, and I'll make a decision. We could come in with something. I mean, we know the instruction is going to be given. It's only a matter of how it's modified and whether I add the additional language, which is easy enough to do. So you can argue that first thing on Wednesday morning. We'll come in. I think the jury's coming back at 9 actually, so we'll come in at 8:30 on Wednesday. Let's see. Next is 375, which you also want to argue, which is.
And my suggestion, Your Honor, this is one of the two.
Okay,
large ones.
I can put it aside.
Yeah, I think
deal.
the others will go quickly.
Okay, we'll deal with this when we deal with 306. All right, we're into the 500 series. Let me just quickly go through before we get there to make sure I don't think there's something I'm missing. Sua sponte. .520, murder with malice aforethought.
Your Honor, we had requested 500,
500 needs to be given if you have multiple theories.
Yeah, I withdraw that, Your Honor. At the moment, there are no lesser included.
I guess I should ask at this point, are the people seeking any lessers?
No.
Not at this time.
I think we're all in agreement. Let me just get a statement, that besides which I think it is a correct statement of the law. I have, for weeks now, been thinking of alternatives and what if this, what if that, just sort of trying to get a head start on whether there's a possibility of voluntary manslaughter or involuntary. And based on the facts of this case, also based on the defense, I don't see it. The problem with a sudden quarrel would be that there's the reasonable man standard, which I don't think anybody would say has possibly been shown, which would mandate a voluntary manslaughter. And on involuntary, given the fact that the gun is inside her mouth, you can't possibly get to things like misdemeanor manslaughter or anything else but where it comes to second degree. If they find, I don't see a theory. So this is a knowing tactical decision, plus which your belief in what the law shows. Is that correct?
It is, Your Honor. I will state for the record that unlike a situation in which there could be lesser included and we're asking the court to roll the dice for us, this is actually a case in which, tactics aside, we agree with the court that there simply isn't sufficient evidence to support a theory other than either acquittal or second-degree murder.
Right. Initially, I think when the case started out, there was a lot of talk of alcohol intoxication, but nothing was presented to the jury that would be sufficient to proceed with that. So based upon that, the court will instruct only on murder.
Your Honor, on that note,
Yes.
and following up on what Mr. Reardon just indicated, one of the things, and I spoke with him briefly off the record this morning, one of the things that I think I'd like to have cleared up, and this may invoke Mr. Rosen getting involved into the discussion as well, since he's going to give at least one of the summations. We don't want to be put in the position of, and I'm not casting aspersions, this was Mr. Reardon's statement this morning, and I appreciated it. He said they're not going to engage in any gamesmanship wherein they don't ask for a lesser, and we don't ask for a lesser, and then someone stands up and in front of the jury says, now, we don't think he did it, but even if he did do it, he didn't do this crime. There's some other crime that he may have committed, et cetera, et cetera.
How could they, given the fact that I'm not instructing? I would cut that line of argument off.
I agree, and I would.
Totally improper.
Okay, as long as we're on the same page. Unfortunately, I've been in the on the receiving end of arguments like that. I don't think that the defense would ever do that. I don't think there would be any sandbagging. I would want to make sure that we're all on the same page. And from Mr. Rosen's comments and Mr. Reardon's comments, I trust that is exact. They're on the same page with me.
And I'm on the same page with everyone, because I would never allow that, given the position that everybody has taken. So does the defense join in 520?
Yes, it does.
Okay, thank you. All right. Let's see. Just double check. The instructions are not going to take very long to read. Now, you are proceeding only on a theory of second-degree murder, correct?
Yes.
Correct.
Let's see. Have to do something. 521 is murder degrees, and either that or we could just add something to 520 that you are instructed if you find the defendant guilty of murder, it's murder of the second degree.
That'd probably be appropriate.
Why don't you just add a line into 520 rather than give a separate? I'd have to modify 521 because it's such a long instruction and just add as a matter of law at second degree, or, you know.
Would you want that right after the...
Just the last, at the end of 520.
Your Honor, my suggestion would be that in the first line, we say the defendant is charged in count one with second-degree murder.
That's fine.
I have no problem with that either.
I have no problem with that. That works for me.
And that'll be the only verdict form that they get.
Okay. Well. Okay. We jump forward to use of a firearm, 3146. What's your position on 3146, use of firearm?
I'm just looking at the amendments, Your Honor, would appear to be appropriate.
Okay, take your time. No, it's- I'm sorry, it's not two separate allegations. I take it back. It's charged under, I think it's 12.53B, which is, let me just double check. Well, under 1222.53B, it's a 10-year enhancement, and under 12022, let me just double check.
3 forms under 12022.5. It's a range. And
Let me think why it's pled this way. Give me a second.
Maybe the 153 only applies to strike offenses.
And that applies to murder. One of the things before, because I know I have thought about this, had there been lessers requested, then the jury would have had to been instructed that if they found a lesser, then this doesn't apply to it, but it does apply to murder. And obviously, you can only have one enhancement. It can be charged under different sections. You can only punish for one. I'm just wondering, I'm just trying to figure out what the, I want to make sure I'm not making some error here. Basically, what it does, it says this is the one you apply. If there's another enhancement, you don't apply the other one, which in this case would be the 12022.5, unless that penalty is greater, which clearly it is not. It'll just read 12022. Well, if it reads .5 though, then it's arranged. What do you want to do?
it should be the .53B, I think.
You want to just dismiss the .5 allegation?
Is it- Actually, I don't have the indictment in front of me, Judge. Did
It
we
says-
actually-
They're both pled.
They're both pled. It says, it is further alleged as count one that said defendant Phil Spector personally used a firearm, a handgun within the meaning of Penal Code sections 12022.5A1 and 12022.53B.
Does that make any sense under what you've just read?
I know,
Doesn't make any
and
sense
that's-
to keep the .5, doesn't it?
I mean, he could be. The bottom line is you can allege each, but the bottom line, because 53B says that you shall put this one if it's the greater, and since it has, if you will, the automatic high term, the other one is a range.
It's 10 mandatory, so let's just get rid of, sure, we'll just dismiss the
Okay,
12022.5.
all right, because of the reason stated in the 12022. And that's done solely for the purpose of, if for some reason something turns up, why don't you hold off on that if you want to do some research on it and come in Wednesday and just...
Okay, we'll look at
okay.
it. We'll look at
That's
it.
the best way to do it.
That's our tentative
Okay.
position, however.
So then,
And we don't have to do it until the, oh no, we have to do it before the verdict form. We need to instruct.
yeah. Anyway, are you joining in 3146?
We don't object to it. no.
Oh, no objection? Okay, that's fine. Thank you. Next is 3530, judge's comment on the evidence, which is is actually just the opposite. It's, oh, actually, you did include
Your
that.
Honor, we've agreed that the prosecution did not intend to submit this. They simply intended to have the discussion in 3550 of
Thank you. I was a little concerned. I mean, I do know one judge that actually did this and was upheld on appeal, but you're not going to get it from this court, I assure you. All right, that's withdrawn. Okay. All right. 3550 pre-deliberation instructions.
We join in that.
Okay. Um, 3590 will be given when the case is over, so we don't, you want to just go ahead and join in that now, and it'll be withheld until the case is completed. Okay, I'll put that. I think we're now down to the discussion of 306 and 375.
And we had that brief pinpoint instruction that we
Oh, yes.
yesterday.
Yes, we need to discuss that, thank you.
This one, Jeff?
No.
No, special one.
No. Special one, right.
Right.
We have special one, special two, and a...
Well, why don't, let's propose, you have more than one special?
There are two submitted by the prosecution, Your Honor.
Under 306, we've submitted
Oh,
two
right.
separate
Okay,
instructions.
let me find 306 and go with that. All right, let me take a look. You want to argue generally why I should give it, and then we can perhaps go from there?
I will attempt to briefly argue why you shouldn't give it, Your Honor.
That's what I mean.
And in that, I'll address both seriatim unless you want the court to respond to one of the instructions, the prosecution to respond to one before I reach the other. I would start with the Baden instruction, Your Honor.
Okay.
And as a general principle that applies to both, and when you look at the commentary, both to Kalchik and Kalkrim, I don't think there's any instruction in the entire, in either volume, where almost the entire use note deals with the problems and reasons why you may not want to give an instruction such as this. We're in the situation in which if the prosecution, putting aside Baden or Lee, proves guilt beyond a reasonable doubt, of course, these issues are extraneous and they'll get a conviction. So what we're talking about is a situation in which a jury looks at the evidence they actually heard dealing with the charged offense and says, you know, maybe we're close, maybe we're the 2-yard line, but we're not there. And then the question is, can they use an instruction about evidence essentially that they didn't see or hear to push beyond the threshold of beyond a reasonable doubt? And California law is clear, I think, in a series of cases that we've cited to the courts, Saucedo and Bell and so forth, that the only circumstance they could do that in is a situation in which the defendant has authorized the delay or failure to disclose, because that supports a reasonable inference of consciousness of guilt, which is a relevant fact as far as the crime is concerned. And secondly, where the jury, on the evidence before it, could make a finding that the evidence which was not disclosed or withheld caused some ascertainable, measurable prejudice to the state's case. So turning to the Baden situation, I think it is just undisputable that Dr. Baden, who the court found, as to Dr. Baden, that Mr. Plord should have disclosed certain facts about his conclusions on Monday. They didn't come out until he was on the stand on Tuesday. He underwent what I think it's fair to characterize as a withering cross-examination, and I don't think the prosecution can turn to this court and say, here is the specific question that I didn't ask on cross-examination because I got the information on Tuesday rather than Monday morning. Secondly, the court heard the testimony of Dr. Andrews, who was apparently in court for the testimony of Dr. Baden, getting ready to prepare to rebut it. He got on the stand a week later. It is, again, simply impossible to find that Dr. Andrews' testimony was less persuasive or complete for hearing the conclusions of Dr. Baden on Tuesday rather than Monday of the prior week.
If I could just interject, because Mr. Reardon wasn't here, Dr. Andrews was not in court.
I know that, and you can get a chance to respond to it, so you may proceed.
Your Honor, and I believe that it is correct that this court has not and will not make a finding as to the Baden testimony that the defendant in any way did anything that would reflect consciousness of guilt in that regard. So if a jury were to, and furthermore, the proposed people's instruction would have the court inform the jury of findings of fact based on information that the jury didn't have before it. And again, either they would use a finding made by the court to convict, which in the wake of Apprendi and Blakely and the rest of the United States Supreme Court authority, this court, I think, would be loath to have them do, or they can't use those findings to convict. They can't attribute to them. They can't find Mr. Spector guilty based on those findings, in which case the matter should not be before them at all. So on that, perhaps what I should do is submit it as to Dr. Baden and then address Dr. Lee separately.
I'll deal with them. Why don't you go ahead and, if you want to argue, Dr. Lee, then I'm going to hear from the people, and then I'll sort of tell you where I'm going with all this, or I believe I will after I hear argument. Go ahead.
In the Lee case, again, I would submit under the controlling precedent that you'd have to find that the defendant was somehow involved in the loss or failure to turn over evidence. I don't think the court has made that finding. I think the court has stated that it couldn't make that finding. There would be no basis for that finding. So I think the 306 would be inappropriate on that fact alone. Secondly, we have a situation in which the court has stated that while it concluded based on hearing testimony that the jury did not, they heard from Sarah Kaplan, they did not hear from Dr. Lee, but the court heard from several witnesses, and based on the information before it concluded that Dr. Lee removed something from the scene, although the evidence before the court was insufficient for the court to make a finding as to what was removed. So it is certainly the case that if the court on the greater evidentiary basis couldn't draw that conclusion, no jury, having heard from Sarah Kaplan, could conclude what it was that was removed from the scene. Therefore, no jury could possibly conclude that what was removed was evidence. The state asked this court to say that Sarah Kaplan testified that evidence was removed. She certainly did not testify that evidence was removed. No one could say that evidence was removed in the sense of evidence having relevance to the defendant's guilt or innocence. So it would be utterly speculative for them to find that the action of Dr. Lee in any way affected or prejudiced the people in terms of their case. If they got in the jury room and said, you know, if they get in there and say we convict, well, this is all irrelevant. Dr. Lee aside, if they say, you know, they're not quite there, but, you know, there's that thing about Dr. Lee and what he removed, and we don't know what it is, but not knowing what it is, we can find that because we don't know what it is, that's enough evidence to boost the prosecution's case over the goal line in terms of reasonable doubt. It would be wholly inappropriate. It would be speculative, and it would have nothing to do with the defendant's guilt or innocence. I mean, one of the problems with 306 is that on the one hand, the court in this situation would say, well, you can consider this for some purpose, but it's not evidence that the defendant committed a crime. Well, if it's not evidence that the defendant committed a crime, it can't be evidence that the jury could rely on to convict them of that crime. So we have specific objections, many objections to the specific language of these proposed instructions, but we would suggest that the best alternative for the court is not to give a 306 instruction. Alternatively, we've submitted to the court a very vanilla instruction which simply says that if you find that there was any loss of evidence, you can consider that whether it affected the other side's presentation. Because in this case, this record is rife with evidence that there was material from the crime scene that was lost and not produced for defense examination. You know, the most outstanding item is the piece of artificial tooth apparently blown out of Miss Clarkson's mouth by the blast of the weapon. Both Dr. Pena and Dr. Anselmo testified they observed the material in the vial that the tooth was contained in, but the evidence was missing when they went to examine it. So that is absolutely, if we're not attributing guilt to the defendant, and we can't, and all we're doing is saying that evidence was lost, then this jury has to be told, if they're going to be told anything, that they can consider the evidence of lost evidence on the prosecution's part, and if need be, we'll make an offer of proof as to 7 different items as to which the evidence wasn't sufficiently preserved that the defense was able to analyze it and potentially use it in their case. So our third alternative, if the court does anything in this regard, and we urge it not to, is to simply give an instruction that says if they find that any evidence was lost or not turned over by one party to the other, they can consider that in deciding the case.
Okay, thank you. Mr. Jackson, Mr. Dixon.
With regard to, I'll take them in turn. With regard to Dr. Michael Baden's aha moment and the defense failure to turn that discovery over, listening to Mr. Reardon, it sounds as though, I mean, his arguments are all fine and good if CalCrim 306 hadn't been adopted by the CalCrim committee. I mean, this is the jury instruction that basically covers incidents like this. And Mr. Reardon goes on at length about, pushing the ball over the goal line, which, I love a football analogy, but it has absolutely nothing to do with the evidence in this case and the conduct by the defense. Now, Mr. Reardon does state the law correctly. You can't use this particular instruction on its own, on its face, to convict the defendant. That's not what the instruction says, and that's not what it would be used for. This instruction specifically speaks to the failure of the defense to do that which it is obligated to do under the law. And there are prices to be paid. There are consequences for conduct. This is not at all, and I'll address this right up front, these incidents are not at all comparable to item number 10, the tooth, that was broken in the vial and ultimately lost. That item was lost. It wasn't hidden. That item was misplaced. It wasn't concealed. Those are differences. With regard to item number 10, and any other investigation, especially an investigation that encompasses 10,000 plus pages of documentation, photographs, and box after box after box of evidence, there are going to be, human errors, and we don't care about that. I mean, there were human errors on the defense team as well, not getting a particular page to us or misbait stamping something or vice versa. That happens, and it happens in every single case. We live in a world of human errors. What we're talking about with regard to Dr. Baden's aha moment and Dr. Lee's situation, which I'll discuss in just a second, are intentional acts by a member of the defense to undermine the prosecution and undermine the court process as we know it within the rules in which we play. Our jury instruction, our proposed jury instruction with regard to the Dr. Baden evidence and the aha theory that just came out of nowhere, and the first time we heard about it was on the stand, is centered on the statement by the court. The court made a finding that that was an intentional act by the defense to gain a tactical advantage over the people. We're not going to turn around and say to the jury, push the ball over the line and find the defendant guilty just because of this. What we are going to say is how much weight can you really give? How much credibility can you give to Dr. Baden and his entire testimony on direct, on cross, redirect, recross, whatever? In the light of that conduct, this instruction is asking the jurors, can you give the weight that the defense wants you to give to their opinion? And I would submit to the court that I can promise that Mr. Rosen, Ms. Bodden, whomever, someone...
I'm sorry, but to me, because he is married to someone on the defense, that to me is a bad look. Like, I would be inclined to not find his testimony credible for that reason alone. Because I would think, well, of course, his wife's on the defense team. Of course he's going to say whatever is favorable to the defense. I can't see it any other way. I just would not. If I was on that jury, I would not find him credible.
He's going to stand up and say, you have to believe Dr. Bodden. We've come up with this physiological theory, this neurophysiological theory, and you have to believe Dr. Bodden. And that testimony will be heavily relied on by the defense to make their points to this jury. And his credibility is now cast in deep relief for this jury. This instruction gives the jurors an ability, and they can take it for what it's worth. It gives the jurors an ability to look at his testimony in the light that's most appropriate, given the conduct of the defense and the first time we heard that. We're not asking that this jury instruction be used to push the ball over the line and find the defendant guilty on his own. And Mr. Reardon knows that's not why this instruction is included in the CalCrims. Indeed, Mr. Reardon, from what I understand, we haven't met before yesterday briefly, he helped write the things. If his comments and his statements to this court were actually accurate, he would have taken this page and burned it and said, no, we're not going to, CalCrim's not going to employ this. This is exactly the kind of conduct that CalCrim was designed, CalCrim 306 was designed to employ. With regard to Dr. Lee, once again, this court held long, thorough, deeply synthesized hearings to determine what happened in that foyer with Dr. Lee. The court heard from Dr. Lee. It's not like anybody's engaging in a knee-jerk reaction. Certainly not this court. You have shown over and over and over you are not willing to make a statement, you are not willing to make a finding unless you have every T crossed, every I dotted. Well, Henry Lee crossed his own T's and dotted his own I's. And this court made a finding that Henry Lee intentionally removed an item of evidence or potential evidence. And with regard to Mr. Reardon's statement that this isn't evidence and you can't call it that, well, how do we know? How do we know that it's not evidence? Anything of potential value found at a crime scene is in fact evidence. It may be useless evidence. I mean, this piece of paper may be useless, but it could be evidence. And the fact is, this court doesn't know whether it's evidence. Mr. Reardon doesn't know and will never know. And I don't know. But more importantly, those 18 or 17 folks sitting in the blue seats, they don't know. Given the fact that this was an intentional act, an intentional removal, an intentional concealment, this is, again, exactly what 306 was designed to guard against. There are consequences for conduct. We can't have these free-for-alls on the defense side or the prosecution side. We have to live in a world of rules. These rules are well founded in 306, and we're not going to stand up. Dixon's not going to. I'm not going to. And if we did, the court would stop us. We're not going to say wrong. What we are going to say is evaluate the tone and tenor and quality of the defense based on this conduct.
Thank you. Did you want to say something, Mr. Dixon?
Only that for a time I was on the CalCrim committee too with Mr. Reardon, and my recollection, it could be wrong, is that he made the same arguments with respect to not including this instruction, and the CalCrim committee chose to include it in the book.
Thank you. Do you need any response? I'm ready to proceed, but if you want to have a response. You're not responsible for what ended up in the volume. That's a committee. The committees are group efforts, and, minority opinions are noted and overruled.
Yeah,
And driven over.
I'll just say that based on my recollection, what Mr. Dixon just said is untrue.
It doesn't matter to me if it's
I'm sure it doesn't, Your Honor.
Okay.
Let me just point out, however, instead of both of our flawed memories about irrelevant discussions, that what the Calcrim Committee has said, quote, page 89, is the court should consider whether giving this instruction could jeopardize the defendant's right to a fair trial if the jury were to attribute a defense attorney's malfeasance to the defendant. One of the points that Mr. Jackson just strenuously made was that you would be telling the jury things based on information you obtained from evidentiary hearings not in front of the jury. He is saying that because you heard evidence that the jury did not, you can direct the jury to make a factual finding that the government will then use to attack the credibility of Dr. Bodden. I submit to the court that one of the problems with this instruction, and it's in the reversals, Bell, Cabral, Saucedo, is that the courts have said you cannot have juries attempting to make findings based on information not before them. If this jury convicts because the court made a factual finding based on evidence not in front of the jury, any conviction that he returned is going to be defective because the court may not find any fact relevant to guilt or innocence. And if the facts the court is not finding are not relevant to guilt or innocence, then they shouldn't be something that the jury should consider.
Okay, thank you. I'm well aware, and it's a concern, at times the appellate courts seem to have put trial courts in what to me is an untenable situation. Clearly, we're to make a decision on whether or not there are discovery violations or other violations, and once we find them, they basically take away all the remedies. On one hand, if you strike testimony or don't allow someone to testify, they tell you that's too harsh, exactly the word, too harsh or egregious a remedy. On the other hand, if you don't do that and instead you attempt to tell the jury how to deal with it, based upon Bell and Saucedo and some of the other cases, they appear to say, well, you know, now you've put that on the defendant and the defendant isn't personally responsible. I made my statements at the time that these events took place. I know I was talking about discovery violations, and Mr. Brunon took some umbrage that I was, bringing in general statements to a specific case, but that was done for illustrative purpose. I think there is a way to harmonize this, and I realize I'm taking a risk, but I'm not going to accept any of the language that's been submitted. What I intend to do, and I'm going to write my own instruction on this, and I'll tell you basically what it's going to say. As to Dr. Lee, it's going to find that based on Sarah Kaplan's testimony, and that's what's in front of the jury. It's not my finding. That if they find her to be credible, then they may consider it only in the following fashion, besides not using it against Mr. Spector personally. But they may consider that in evaluating whether the people have had all the evidence at their disposal to present their case. And that's basically what it's going to say as to Dr. Lee. As to Dr. Bodden, what it's going to say is, and list exactly what took place, which is that the defense had a responsibility to turn it over. The earliest date when they should have turned it over and the time they should have turned it over is no later than Monday morning, and you might give me the dates. I may have to fill in the dates. And it wasn't turned over until Tuesday. So the jury's going to know exactly the time lapse. And you'll be free to argue that, so what? It's the difference of 24 hours. But I believe that even in those 24 hours, and I'm not going to put in the instruction that I think it was for tactical advantage, but that's why this instruction is being given, that because of that delay, they can use that in evaluating Dr. Bodden's testimony. And I'm going to use the term evaluate. I'm not using the term credibility. I'm using the term evaluate. And you can argue it as you see fit. It's as far as I think I can go. I would like to go further than that. I don't think I can safely, and that's what I'm going to do.
You're
Okay. I know they're not completely done with this argument, but they won't stop. They're just on and on and on and on and on. Okay, we will pick that up tomorrow because we are going to start a new trial today out of Georgia, and it sounds really good because I think there's some far-fetched stories going on. I don't know, but it sounds like it's going to be a really good one. It is also about to storm here. I'm going to try a new setup. So please bear with me. This stream will redirect to the next stream, and I will be back in a few minutes. Hopefully, if not, it'll be a little bit long, but we'll see what happens. So I will see you over there in a few minutes.